our final guest is a crowdfunding advisor to numerous startups around the globe and is globally recognized for her thought leadership on legal implications relating to cryptocurrency policy and regulations. Joining us now from Washington, D.C. is Maureen Murat, attorney advisor at the D.C. Department of Insurance, Securities and Banking and adjunct professor at the University of New Hampshire Franklin Pierce School of Law. Welcome, Maureen.
Hi, good morning. Thank you for having me.
Great to have you here. All right, so one of the stories that caught my eye yesterday was that investment bank JP Morgan Chase has been testing out blockchain payments between satellites in Earth orbit, according to a Reuters report. I'd love to hear what the government thinks about all of that.
That is a great question. I think when you think about what they were really testing was the ability to have IoT devices, Internet of Things devices to be able to communicate with each other, and testing out blockchain payments was just a cool way to do that. And of course, they had to go into space to do that. So, to add an additional cool factor to it. But in terms of, I guess, what the government is thinking, I think they're still, as Daniel even mentioned earlier, government agencies are still really just looking at what's going on and thinking about how this might implicate actual individuals. I think when, especially on the federal government side, when they're thinking about IoT, they're really thinking about privacy issues, which is a major issue when you have so many devices talking to each other, payments, et cetera. And, sometimes the point of failure is actually the user of that device.
What do you think is going to happen with the SEC case against Ripple, and should XRP holders be worried about this?
That is a great question. I have been following that case. This is not the first time the SEC has that Ripple has been in trouble. I mean, they actually had a settlement with FinCEN, and the way they had to pay, a settlement amount. And so this is not something new for Ripple in terms of, being called in by the regulators. But I think that when it comes to XRP, the SEC doesn't, my opinion, doesn't make these cases without putting a lot of thought and effort and research into these matters. So I think they are going to show that even though it might not appear to be, and we've seen this in some of the guidances that they put out, that even though it might not appear to be a security on its face, the way that the business interacts with the people who are purchasing them, what is in the mind of the people or the investors when they get these XRP, if you're not a security, then should you be on an exchange, and should you be, and I'm saying this generally because I don't want to, I know with the blockchain crypto community, it's a touchy subject, but if there's an expectation of profit and there are, investors thinking that this is something that can, essentially help them gain some sort of wealth, then the SEC has to look at that. They don't only look at securities, they also look at how the market is being manipulated. They also look at how investors are can be protected. And they also look to make sure that people aren't, laundering money for various reasons. So they have a lot of initiatives under their, jurisdiction.
So, Maureen, this brings us to the Howie test. It's been around for almost a century. It's the Supreme Court case and it's what the SEC uses to determine what's a security. Does it still work in regulating crypto, or do we need an update, or does something have to change? Another case, perhaps? Is the Howie test outdated?
Well, I mean, I don't think that when we thought of when the Howie test came about, 70, 80 years ago, that we had expected that it would, be akin to virtual currencies or anything digital, right? Because the Howie test was really about an orange grove. So in terms of whether it's outdated, I think it's outdated in the sense that what they're trying to compare is really like, digital gummy bears to oranges. So I think in that respect, yes, it's a little outdated. But, I'm an attorney, right? So legal precedence matters. And so that also means a lot of legal precedence has to do with interpretation and the different facts of a case that make it kind of line up. I mean, when the SEC said that the Howie test and the elements in the Howie test could be applied to these types of currencies, I think they made a good case for it because they, pulled out the 4 elements. And if you meet all of those elements, then you're a security. Now, if you don't meet those elements, then you're not. Granted, a security is not just investing in a business. The definition of a security is very broad. So, it doesn't just fall under the Howie test. I think it's just a very popular test, I guess, because it came out during a time when there were a lot of ICOs and there was a lot of craze. And so people kind of held on to that test. But the SEC has lots of other cases and other, precedent that has been set that they can use to also support their cases.
Great. Thank you so much, Maureen, for joining us and giving us an update on some of the legal issues that are being thought through in D.C.
Thank you. Thanks for having me.
All right, that was Maureen Murat, attorney advisor at the D.C. Department of Insurance, Securities and Banking, and adjunct professor at the University of New Hampshire Franklin Pierce School of Law.